Good evening, everybody. We welcome you to this learning session on Ndps Act, Procedure and Practice. This is the second session which we are doing in the continuation of the first session, where we had the keynote speaker Shri Baljinder Singh Sarang, Additional District Judge cum Faculty Member, Chandigarh Judicial Academy, who was there with us for the earlier session, and the interest and the request made by many of the members made us to continue with this session, which is also going to be as interesting and is also likely to be as useful as the first one was there. So I welcome you, but before that, I am really thankful to Honorable Shri Baljinder Singh Sarang, who has kindly and graciously consented to be for today's event. As we shared in the last event also, Shri Baljinder Singh Sarang, who has done his LLB from Punjab University, Chandigarh in the year 2000, and thereafter he has practiced in the High Court of Punjab and Haryana and has been handling civil, criminal and various other matters. He has been the Standing Counsel of UT Chandigarh and also on the panel of the Punjab State Legal Services Authority. In between, he was selected as Special Public Prosecutor in the CBI by the UPSC and had a very short stint there. After resigning from there, he has been into the legal services as Deputy Legal Advisor to the Government of India. But he did not join there and resumed his practice in the High Court. In the year 2015, he got selected to the Superior Judicial Services as Additional District and Session Judge in the state of Punjab and stood first in the merit list. He has authored and penned various articles on the legal topics, and currently there are 6 books which are under process of publication awaiting the permission of the Honorable High Court. Presently, he is working as a faculty member on deputation to the Chandigarh Judicial Academy. It's our fortune and good luck that we have such a wonderful personality who has always been very, very helpful to the legal fraternity. Welcome, Shri Baljinder Singh Sarang ji. Sir.
Thank you so much, Saurabh, for the nice introduction. I welcome, first of all the participants who have joined us today in this session by sparing their valuable time. I hope that this session would also be useful to them, just like the previous one. This session is in continuation of the previous one. In the earlier session, I have shared with the participants the basics of the NDPS Act. I dealt with the definitional part, the offences part, the regulatory and the probatory part of the NDPS Act. And today I shall be dealing with the procedural part. In this session, I would be focusing and emphasizing on the practical aspect which the lawyers or the judges deal with. Now, first part in this is cognizance and bail. Now, all of us have read section 190 of CRPC, which deals with cognizance of the offences. And there are 3 modes provided under the CRPC for the court to take cognizance. One is police report, second is complaint, and third is suo motu. Now, under this NDPS Act, exclusive jurisdiction is vested in the special court under section 36A to deal with the cases. Now here there is twofold segregation and bifurcation. Offences which are punishable up to 3 years of imprisonment are to be dealt with by the judicial magistrate first class in terms of the part 2 of schedule 1 of CRPC. Only the offences which are punishable beyond 3 years are to be exclusively dealt with by the special court. Second aspect is that if in the same transaction offences other than NDPS Act have also been committed, then the special court has the extended jurisdiction to deal with those offences also, along with the offences under the NDPS Act. Then the initial remand is to be granted by the regular magistracy, which has been saddled with the obligation to perform all the acts stipulated in section 52A of the Act, that is certifying the inventory produced by the officer in charge of the police station, then allowing him to draw the samples and various other acts dealt therewith. The next aspect is that after this first remand, then accused is liable to be remitted to the special court for further proceedings, which means further remand, default bail, bail, as well as trial. So far as the Act is concerned, the special court is vested with the power to take direct cognizance of the offences under the Act, and there is no requirement of sending the case through the magistrate or committal of the case through the magistrate to the special court. Next aspect is default bail. Now under the Act, there is twofold division for default bail. The provisions of the CRPC in this regard have been slightly modified. Offences in which the punishment is up to 10 years under the Act, that is, which includes all offences relating to possession of intermediate quantities of contraband, the time period is 60 days to file the police report. In case of offences involving commercial quantity and offences under section 19, 24 and 27A, the time period has been extended to 180 days. Otherwise, under the CRPC, we have 90 days, but under the NDPS Act, in these offences, we have the time period of 180 days, which time is extendable up to 1 year on satisfaction of certain conditions. Only on the elapse of the time period, the accused shall get the right to default bail. Now, so far as the conditions for extending the time period up to 1 year is concerned, it can be extended by the by the court on the satisfaction of the following conditions. First is, there should be a report of the public prosecutor. Second, It should indicate the progress of the investigation. Third, the report of the prosecutor should specify the compelling reasons for seeking the detention of the accused beyond the period of 180 days. A notice should also be issued to the accused. What could be the compelling reasons? Those are not specified in the act as such, but those must necessarily bear rational nexus with the completion of the investigation. It should not reflect lethargy or inaction or negligence on the part of the investigating agency. If it is so, then the court shall reject the extension application. Other ancillary matters which may arise along with this are that when the accused should file the application for default bail, it is only on the expiry of 60th day or 180 days that a right accrues to the accused for default bail. On the 61st day or on the 81st day, the accused is entitled to file the default bail application or make an oral request to the court to release him on bail. Now, if in a given situation, the investigating agency through public prosecutor has filed the extension application on the 181 day, in that eventuality, if the accused has filed the application for default bail, then he is entitled to the same. The state should file the extension application either before the expiry of 180 days or before the accused avail of his right to default bail. If the accused had already filed the default bail application, a subsequent application by the state seeking extension of time will not be entertained. Next is that so far as the report of public prosecutor is concerned, he is required to independently apply his mind to the request of the investigating agency before submitting a report to the court for extension of time. He is not merely to act as a post office or a forwarding agency. He should properly weigh the reasons disclosed by the investigating officer seeking extension of time, and then finding them to be reasonable, should then prepare a report and forward the same to the special court. Next is the second part of section 37, which relates to imposition of additional conditions. Now, so far
Farah sir, can I make
Yes.
you a request? I think there is
Yes.
some problem coming in the live audience, so we would need just 2-3 minutes of yours.
Okay,
We are
okay,
just rectifying the problem. We're
okay.
trying to correct it, sir. Just give us 2 minutes, sir. Sarasar, I think there was some problem which had come, but we are live again. So probably, uh, I think if we could, I'm really sorry for the technical glitch, and if we could have a little, we could take it a little back for 4, 5, 7 minutes. I shall be personally obliged, sir, because there was some technical glitch which took place. Anyways, so we were just hearing with the wonderful views of Shri Baljinder Singh Sarah, who is an additional district and session judge and also a faculty member in the Chandigarh Judicial Academy, on the part two of this enriching session of NDPS procedure and practice. Sir, please, we would like to hear you
Yes.
now. And from a little rewind mode, I'm really sorry for apologies for sir. There was some technical glitch which took place.
Probably last part, we were dealing with default bail.
Sir,
Yes. So
if you
the
could
time
just give a
limit,
glance, if you could give a glance for 2 minutes for what the viewers who've just joined us. Sir. I'm really sorry, sir.
we were on the default bail under the NDPS Act.
Sir,
So under the Act, there is twofold segregation. Offences which are punishable up to 10 years of imprisonment. The time period is 60 days. And for the offences involving commercial quantity and offences under section 19, 24, 27A, the time period has been extended to 180 days. Unlike CRPC, where the time limit is 90 days. Now, this 180-day time period is further extendable up to 1 year, subject to the satisfaction of certain conditions, which we have already noted in the previous lecture also, that there should be a report of the public prosecutor, which should indicate the progress of the investigation. It should disclose the compelling reasons for seeking the detention of the accused beyond the period of 180 days. A notice should be issued to the accused. Now, what compelling reasons are has not been specified in the Act, but those must necessarily bear rational nexus with the completion of the investigation. It should in no case indicate the lethargy or inaction or negligence on the part of the investigating agency. If it is so, the application is liable to be rejected. Now, the prosecutor is not to act as a mouthpiece only or a post office. He is required to independently apply his mind to the reasons disclosed by the investigating agency, and if he finds those to be genuine, only then make a report to the court seeking extension of time. Then the court is required to independently apply its mind to the report of the public prosecutor, and after hearing the accused or issuing notice to him, would be deciding upon the same. Then we were on the second limb of section 37, which relates to imposition of additional conditions on the grant of bail. Now, these conditions are mandatory in nature. The court cannot order the release of the accused on bail unless these conditions are satisfied. These conditions are applicable to the regular bail application, the anticipatory bail application, as well as suspension of sentence application before the appellate court. Then next part, important part, is procedural part relating to arrest, search and seizure. Now, most of the issues which crop up before the court relates to the procedural part. So far as procedural prescriptions are concerned, there is twofold segregation or bifurcation. There are pre-recovery procedural prescriptions which are listed in section 41 to 50, and there are post-recovery procedural prescriptions which are listed in section 52, 52A, 55, 57 and 57A of the Act. Now, in pre-recovery procedural prescriptions, there is threefold classification. If we have a look at the structure of the provision under this part, first is classification on the basis of warrants or authorization. So whether the arrest, search or seizure is with warrants or authorization, or is it without warrant or authorization, which is listed in section 41 and 42 of the Act respectively. The second classification is on the basis of place, whether the search and seizure is to be effected in a building, conveyance, or enclosed place, which are the private possession of a person, or whether the search and seizure is to be effected in a public place or in transit, which is listed in section 43 of the Act. And last classification is based upon the personal search and the article search, which is listed in section 50 of the Act. Now, if we take the first part, that is first classification, we will notice that in section 41, there are twofold agencies which have been empowered to issue warrants and authorizations. So far as the warrants of search and seizure are concerned, the power is vested with the judicial magistracy. So far as authorization is concerned, the power is vested with the gazetted officer of certain departments. We will also notice that the procedural safeguards would be lowered or less or diluted as we move from judicial magistracy to the other officers under the Act. Reason is that it is in the working of the judiciary itself that any order which is passed by the court must be based upon reasons. It must be supported by some material. It requires independent application of mind, and only thereafter the court will issue the warrants for search and seizure under the Act. So far as the gazetted officers are concerned, they can also issue the authorization to their subordinates, but there are certain procedural safeguards which they are required to follow. Now, if we see the difference in the two parts of section 41, part 1 of section 41 relates to judicial magistracy, and part 2 relates to the gazetted rank officers of various departments. In part 2, the authorization can be directed by the gazetted rank officer to any subordinate officer, but that subordinate officer should be superior in rank to a peon, sepoy, or constable. Whereas judicial magistracy is concerned, it can issue the warrant of arrest or search or seizure to any person. Next is the power of magistracy to issue warrants can be exercised when the judicial officer has reasons to believe that the person has committed any offense punishable under Chapter 4. And this reasons to believe must be based upon some material or basis. Whereas the power of authorization by the gazetted rank officer can be exercised if he has reasons to believe either from his personal knowledge or any secret information, in which case it must be taken down in writing. So this is the additional safeguard in case of gazetted rank officers, which is missing in case of judicial magistracy. Then second is section 41 and 42. In 41, we have judicial magistracy and gazetted rank officer to act under the Act. In section 42, we have other empowered officers who are inferior to the rank of gazetted rank officer, but they must be superior to the rank of peon, sepoy, or constable. In 41, the judicial magistracy or the gazetted rank officer can order arrest, search, or seizure by day or by night. Whereas in case of 42, the empowered officer can do the needful between sunrise and sunset. There is no limitation. But when he is to act during the night time, that is between sunset and sunrise, that he can do only in case of emergency situations, when he has reasons to believe that a search warrant or authorization under section 41 from the magistracy or the gazetted rank officer cannot be obtained without affording an opportunity for the concealment of evidence or escape of the offender. Now, in this eventuality, when he is going to act in an emergency, he is required to record the ground of his belief and within 72 hours send a copy of these grounds to his superior official. Then we can refer to another aspect in section 42, that if a gazetted rank officer himself is making the search and seizure, in that case section 42 is not applicable. Only section 41 subsection 2 is applicable. So a gazetted rank officer need not comply with the additional procedural safeguards given in section 42, that is recording of reasons, sending copy of this to the official superior within 72 hours. These would not be applicable. Then third is, the second classification is with regard to search and seizure in a public or a private place. So here the segregation is located in section 42 and 43 of the Act. 42 we have already stated applies to private places. 43 applies to public places or conveyance in transit. In 43, there is no safeguard as such. There is no procedural stipulation as such to be followed. So one question before us is whether the empowered officer who is acting under section 43 of the Act and making search and seizure in a public place, even if he has received the secret information, is it necessary that he should comply with the procedural safeguards of section 42? Answer is no. When the arrest, search and seizure is being effected in a public place or from a conveyance in transit, in that eventuality, the safeguards of section 42 are not applicable. The next is meaning of public place. The definition given in the provision is not exhaustive and it is only exclusive in nature. It includes public conveyance, hotel, shop, or other place intended for use by or accessible to the public. So the test laid down in the Act to identify whether a place is a public place or a private place is not the ownership of the property, but it is the purpose or intent for which the property is there. If it is meant for use by or it is accessible to the public, in that case, even if the place is owned by a private person, then also it will be treated as a public place. Like hotel, shop, they have specifically included these in a public place, though their ownership may be in private hands. But a room in a hotel has been treated as a private place. The next important part is chance recovery. So whenever there is a case of chance recovery, in that case, there is no need to comply with the procedural prescriptions of sections 41 and 42 of the Act. For instance, let us say there is a snap checking by the police official at a Naka. While checking, certain contraband was recovered from the vehicle or from the person. Now, since the contraband has already been recovered by chance, in that eventuality, question of applying section 41 and 42 does not arise. But the Act says the moment the contraband is found or accidentally found, in that case, the further proceedings must be done in accordance with the provisions of the Act. So therefore, if the person who has effected the recovery was not empowered under the Act, then he is to hand over the investigation to the person who is empowered to act under the Act, or whatever other formalities are required under the Act. If he himself was the empowered officer, he is required to comply with all those formalities. Then third classification is based upon the personal search and the search of the article. The dual purpose of section 50 is one, to protect a person against false accusation and frivolous charges, and second is to lend credibility to the search and seizure conducted by the empowered officer. Now, section 50 contemplates the interposition of the magistracy or a gazetted rank officer whenever a personal search is to be effected. Now, even if the search is being conducted by a gazetted rank officer himself, then also he is required to comply with the provision of section 50 of the Act. He is required to give the offer to the suspect that he has a right under the Act to get himself searched either from another gazetted rank officer or from a judicial magistrate, in the presence of judicial magistrate. Now, the provision of this Act, section 50, were diluted by the Amendment Act of 2001, which added subsection 4 and 5 to the Act. Now, it contemplates emergency situations where an authorized officer, instead of taking the person to the nearest gazetted officer or magistrate, can proceed to search the person by complying with the general provision of search under the CRPC. But it is only in case where the compliance of the offer under section 50 is not feasible, and if he acts in this emergency situation, in that case he has to record the reasons for the belief which necessitated such search, and within 72 hours he is required to send a copy of the same to his superior official. Now, so far as the meaning of personal search is concerned, it has been clarified and interpreted to include the body of the human beings as presented to the public view, usually with its appropriate coverings and clothings and footwear. So the question whether compliance with section 50 is required when contraband is recovered not from the personal search, even though search of both the person and bag was conducted. Earlier there was some confusion that if section 50 was not complied with while conducting personal search, even though no contraband was recovered and it was recovered from some article, bag or conveyance, in that case it would have bearing upon the evidence collected thereof. But subsequently, in the year 2019, the Apex Court in the case of State of Punjab versus Baljinder Singh has clarified this aspect, that if the contraband was not recovered from personal search, but was recovered from either the bag or some other article or conveyance, in that case, non-compliance section 50 would not have any bearing on the recovery effected. Now, next important aspect is whether the offer under section 50 should be individual or joint. Now, here there are certain guidelines laid down by the judicial courts, some of which are that the offer should be individual and not joint, because joint offer will create confusion in the mind of the suspects. Offer may be given orally or in writing. The suspect should be clearly apprised of his legal right in clear and equivocal terms. What language is employed will depend upon the facts and circumstances of the case, but it should be understood by the suspect. A preparation of mere consent memo is not sufficient compliance with section 50 of the Act. Now, next part is post-recovery procedural prescriptions. Here we have disposal of persons arrested and article seized. Then we have disposal of seized contraband. We shall study this when we deal with the link evidence. Then we have report of arrest and seizure, link evidence, infraction of standing instruction of 89/2015, which have been supplemented by the decision of the Apex Court in Mohanlal case. Now, so far as the effect of non-compliance of these procedural prescriptions noticed above are concerned, so far as 42 is concerned, its non-compliance is considered to be fatal, but the delayed compliance with satisfactory explanation is acceptable. The non-compliance of procedural safeguards for search and seizure under CRPC, they as such are not, they would not render the search illegal per se, but its effect shall definitely have a bearing on the appreciation of the evidence in the case. Infraction of 50 is fatal, and any evidence collected in infraction thereof will not be taken into consideration. Similarly, 52 and 57, they as such are not mandatory, but they will definitely have bearing upon the appreciation of the evidence collected by the investigating agency. The next part is, can informant be an investigating officer? Earlier, the Apex Court in 2018 held that the informant police officer should not be the investigating officer. But subsequently, the judgment delivered in Mohanlal case was given prospective effect by the Apex Court in Varinder Kumar case. And now finally, the matter has been referred to the larger bench by the Apex Court in the case of Mukesh Singh versus State, Narcotic branch of Delhi, 2019 Supreme Court. Now, next important aspect is link evidence. Now, first of all, let us understand what this link evidence is under the NDPS Act. Basically, link evidence implies that the integrity of the case property should be maintained from the point of effecting recovery till its production before the trial court or its destruction or disposal in terms or in accordance with the law. Now, if we examine link evidence in the context of the NDPS Act, let us see what are the steps from the point of recovery till its production. Now, the first step is that on the search being effected, either of the person or of the article or conveyance, once the contraband is recovered from this at the spot, the investigating officer is required to weigh the contraband, draw samples, then seal it by making it into parcels, He is further required to fill the Cfsl form at the spot, prepare all the memos at the spot. Now, there has been a slight change in this procedural aspect after the standing orders of 2015. The earlier standing order was of 1989. Now, so far as the 2015 standing order is concerned, it says that once the contraband is recovered at the spot by the investigating officer, he need not draw any sample at the spot. All he is required to do is to seal the entire case property, the contraband, convert it into a parcel, fill the Cfsl form. But earlier to this notification or standing order of 2015, the investigating officer was required to draw samples at the spot as well. So once this process is done, he is further required to prepare the memo at the spot, send the RUCA to the police station for formal registration of the FIR. Now, sometime a problem arises that when the investigating officer is undertaking this entire exercise at the spot, there is no formal registration of the FIR, and he is preparing the recovery memo, consent memo, or different other memos at the spot. But on the memos, FIR number is recorded. Now, this creates a problem. Why? Because at that point of time, formal FIR has not been registered and he does not have the number of the FIR. So if he does not have the number, it is not possible for him to record that number on the memos being prepared at the spot. Once RUCA is dispatched from the spot to the police station, formal FIR would be registered by the concerned police official in the police thana or police station. Thereafter, that messenger will bring back the number of the FIR at the spot, and only thereafter the number of the FIR can be recorded on these memos. Now, this aspect is ignored by the investigating officer while undertaking this exercise. It is not recorded either in their case diary or in the memos prepared by them that the case FIR number has been put subsequently when the messenger came back from the police station by getting the number of the FIR from the police station. So this aspect should be taken care of. Otherwise, it will render the entire proceedings suspect with the court, and it may give rise to a suspicion or a reasonable belief that this entire exercise was undertaken while sitting in the police station. Now, after having done this entire exercise at the spot, the Act says that the investigating officer is required to bring everything to the officer in charge of the police station, the accused, the contraband, everything. Another important aspect is that when he has sealed the case property at the spot, he is required to hand over his seal to either the independent person if he has joined in the search and seizure proceedings, or to some other police official who is a member of the police party. But the seal should not remain with him. The idea is that there should not be any reasonable suspicion of tampering with the case property at any stage. So once he reaches the police station, he is required to hand over everything to the officer in charge of the police station, who is required to verify the facts of the case from the investigating officer. take charge of the accused, take charge of the contraband, Cfsl form filled at the spot, and thereafter he is required to put his seal again on the parcels as well as samples, if any, taken by the investigating officer at the spot. Thereafter, he is to either keep the case property under his own lock and in his custody, or he may deposit the case property in the Malkhana by making proper entries in register number 19 of the police station. Now, thereafter, next step which he is to undertake is to prepare an inventory of the entire articles as per section 52A of the Act, and thereafter forward the accused as well as the case property to the Ilaka magistrate. There, he is required to file an application before the magistrate. The magistrate would allow drawing of samples from the case property after he has checked with the seal impression upon the case property with those on the Cfsl form. Thereafter, he is required to allow taking of photographs of the contraband or the conveyance, if any. After having done this, the magistrate is required to certify the inventory prepared by the IU. So therefore, these are very important steps, that is allowing the taking of the samples. Now, after 2015 standing order, the sample are to be drawn in the court and not at the spot. So while drawing the representative samples in the court, the magistrate is required to take extra care. He is required to verify the seals on the case property with the Cfsl form. Then he would break open those seals. Then he would allow drawing of the representative samples from the bulk parcel. He would also require to wait. And after doing all these needful activities, he is again required to prepare those into the sample and seal it with his own seal impression. Now, the sample which is drawn in the court, one sample is required to be sent to the Cfsl laboratory. One representative sample and the bulk parcel are required to be deposited with the judicial Malkhana. Now, this the officer in charge of the police station can do either at once or after some time. Now, if he does the needful immediately, it is all the more better. But if he takes the bulk parcel, representative parcel, and the other parcel to the police station, then he is further required to keep it in safe custody till the needful has been done. So any delay in dispatching the sample again would reflect badly upon the investigating agency. So all these steps are to be taken. Thereafter, the investigating officer is required to deposit the bulk parcel in the judicial Malkhana and one sample. The other representative sample he is required to dispatch to the chemical examiner for testing. Now, this entire linkage of steps is called as link evidence. The judicial courts have evolved the test of reasonable probability of the chances or the probability of tampering with the case property coupled with suspicious circumstances. So the accused is not required to prove beyond reasonable doubt that the link evidence is missing beyond reasonable doubt. If he is able to show the probability, high probability, that at any stage there were probable chances of tampering with the case property, and this is supplemented by suspicious circumstances of the case, then the court will hold that the link evidence is missing. The next is non-production of case property. Now this will assume importance in two situations: where the case property is available with the prosecution but has not been destroyed in accordance with the rules stipulated by the central government under section 52A of the Act, where an inventory has not been prepared as per provision of 52A. There it shall assume importance. In those situations where the case property has already been destroyed in accordance with the provisions of the Act, the question of producing the case property does not arise. In that case, the preparation and certification of the inventory by the magistrate becomes most material. If there is some problem in that, then again the case of the prosecution will again become doubtful. Then next is non-sending of Cfsl form. The filling of Cfsl form at the spot by the investigating officer is important for two reasons. One, to lend authenticity to the search and seizure proceedings at the spot. Two, to have some material subsequently to verify whether the seals effected on the case property at the spot matches with the one which are there on the Cfsl form. So therefore, this aspect is very important. The Cfsl form is required to be filled at the spot by the investigating officer. He is to append the facsimile of his seal on the same. Thereafter, if the officer in charge of the police station, he is also required to append the facsimile of his seal on the Cfsl form when he sealed the bulk parcel or the case property after receiving it in the police station. Then the learned magistrate, while proceeding under 52A of the Act, is also required to append the facsimile of his seal on the Cfsl form. So there shall be 3 facsimile of seals on the Cfsl form at every stage to verify the link evidence in a given case. The next is delay in dispatching sample. Mere delay as such is not fatal, but if it is coupled with the suspicious circumstances, then it becomes material. Non-examination of linked witnesses again become material in a given case. And if there is an association of stock witnesses in the such proceedings, then that also reflect badly on the case of the prosecution. The testimony of such stock witnesses will not be believed, and it may affect the case of the prosecution otherwise also. Now, in case of recovery effected from the premises in the absence of the accused, the prosecution is required to establish the possession of the same with the accused. Unless that is done, the accused cannot be held guilty of the offense. Then we have standing instructions, which deals with the sampling, sealing, disposal of case property. Their non-observance as such is not fatal, but is definitely material for appreciation of the evidence of the prosecution. Then comes the case of retesting. Now, so far as retesting is concerned, unlike Drugs and Cosmetic Act or Pesticide Act, Ndps Act does not contain any specific provision for retesting of the sample contraband. But the judicial courts have laid down certain grounds on which retesting can be allowed. First is where the sample contraband sent for examination is lost in transit. Second, when the sample could not be traced before the test was conducted by the laboratory. Third, when the sample would have been subjected to damage during transit or at the laboratory. And last is where the seal found affixed upon the sample does not match with the seal affixed upon the Cfsl form. Next is the time limit for seeking retesting of the sample contraband. Now, the apex court in Thana Singh case has set forth the time limit of 15 days from the receipt of the copy of the final report for moving an application for retesting. The grounds we have already noticed. The time limit has been fixed, that is 15 days, and it can be sought within this time limit. Then next come disposal of case property. Now, regarding disposal of case property, we have the standing orders dated 13 June 1989, which prescribes the procedure to be followed for seizure, sampling, safekeeping, and disposal of the seized narcotic drugs and psychotropic substances. Now, this was supplemented by the standing order of 2007, which now stands superseded by the standing order of 2015. Now, for disposal, seizure, sampling, safekeeping of the contraband, the standing instruction of 89 and 2015 are relevant, which have been further supplemented by the apex court in case of Union of India versus Mohanlal in 2016. And it has also been held that if there is inconsistency between the 89 standing order and 2015, the latter one would prevail over the previous one. Now, for disposal of the case property, one drastic change which has been effected by 2015 standing order is that earlier the investigating officer or the drug disposal committee was required to file a written application before the concerned court and seek its approval before destroying the contraband. Now, this has been done away with by the standing order of 2015, and now the procedure laid down is that they can do so on their own without routing their application through the court. Under the previous standing order of 89, it was incumbent upon the DDC to move an application before the concerned court and seek its approval before destroying the case property. Now, in Mohanlal case, they have laid down few parameters. In cases where the trial has been concluded, finally, before 29th May 1989, the apex court has relaxed the procedural prescriptions of the standing orders and has held that drug disposal committees shall dispose of the contraband without any further verification, testing, or sampling. Now, drugs which were seized after May 1989 and where the court process has been over till the highest courts, there also the apex court has directed the drug disposal committees to adopt the above procedure and destroy the stock under the supervision of the head of the department concerned without going into any verification, testing, sampling, etc. Now, cases in which the proceedings are still pending before any court, there the competent officer shall move an application under the 2015 notification before the drug disposal committee. So there is no requirement to route the application through the court, and the drug disposal committee shall dispose of the drugs without any further loss of time. Then, so far as the general procedure for sampling storage is concerned, this is given under the 89 notification, which has been slightly modified by 2015 notification. The sampling at the spot is not required now. The bulk parcel is to be seized and sealed at the spot by the investigating officer, and then the sampling process will be undertaken before the magistrate under 52A of the Act. Then we can refer to another provision which is important, that is punishment for vexatious entry, search, seizure or arrest under section 58. Now this is a deterrent on the investigating agencies to misuse their powers, and it imposes a check on them. In case there has been a vexatious search, entry, seizure or arrest, in that case the concerned investigating officer is required to be prosecuted under this provision and punished also, but notice and opportunity of hearing must be given to the concerned officer before passing any order under this provision. Then next come confiscation and forfeiture. Now this is also one of the important area under the Act. The Act seeks to confiscate and forfeit not only the narcotic drugs and substances, but also the conveyances, other material, apparatus, paraphernalia, or sale proceeds out of dealing with these illicit drugs and substances. Section 60 deals with the confiscation of contraband, materials, apparatus, utensils, other paraphernalia used in its manufacture, production, growth, etc., any animal or conveyance used in carrying it. 61 deals with confiscation of goods used for concealing illicit drugs or substances. Now here I would like to draw the attention of the participants that in some cases before the court, what happened is that like a truck driver who is carrying, let us say, 200 bags of pesticides or cement or any other articles, is found in possession of 1 kg of opium, which he was carrying on his person or in the compartment of the driver. Now the investigating officer sees the entire truck along with this cement or any other article which the truck driver is carrying on his truck. Then in that case, these very goods which are being carried on the truck, they are not used for concealing illicit drugs or substances. So they are not liable for any confiscation under the Act. It is only when these goods are used for concealing the illicit drugs or substances, only then they are liable for confiscation. So remember that whenever such a situation occurs, then for the truck, this Spurdari application is maintainable. But for the release of those goods, which has got nothing to do for concealing the illicit drugs or substances, the application should be for finally releasing those goods, because they are not the case property. They are not required for any purpose. They are meant for being transported to some destination. So in that eventuality, application should be for final disposal of those goods. And for truck, it should be Spurdari, because truck was being used for carrying the contraband. Then 62 deals with the confiscation of sale proceeds of illicit drugs or substances. For this we have a separate chapter dealing with the procedure. I shall be dealing with this a little later. Now the owner of a truck or a conveyance can avoid confiscation if he is able to prove two factors. One, he proves that it was so used without his knowledge. Two, that it was so used without his connivance or connivance of his agent or the person in charge of the animal or conveyance, and that each of them had taken all reasonable precautions against such use. So if he is able to prove these factors in the confiscation proceedings, then the vehicle or the conveyance is liable to be released. Now, the confiscation proceedings can be taken at any stage. These can be done by the court irrespective of the result of the trial. So whether the accused is convicted, acquitted, by giving benefit of doubt or discharged, then also it can be undertaken. Even if the offender is not known, then also this can be undertaken. Now, no order of confiscation of an article or thing shall be made until the expiry of 1 month from the date of seizure, or without hearing the person who may claim any right thereto, and the evidence which he produces in respect of his claim. So these are separate miscellaneous proceedings. The file is to be separated from the main case. It can be dealt with along with the case itself, or it can be dealt with at the end of the case. Separate evidence is required to be given by the person whose vehicle or conveyance, or who is claiming interest in this conveyance. And after evaluating the same, then only the order of confiscation can be made. There is also a provision for immediate sale if the same is liable to speedy and natural decay, or the sale is for the benefit of the owner. The next important aspect is immunity from prosecution. This can be tendered by the central or the state government, and it has to form an opinion, and reasons for such opinion has to be recorded in writing. The object for tendering immunity is to have the evidence of that person. The competent authority can also withdraw the immunity if there is a violation of the condition of true disclosure. Now, we also have provision of tendering pardon under section 306, 307 of CRPC. Now, there the power is vested with the court. But here under 64, the power is vested with the central or the state government. Now, even if the tender of pardon has been rejected by the special court, then also the central or the state government can independently apply this provision and grant immunity from prosecution to the accused. Now, next is immunity from prosecution to addicts volunteering from treatment. This is also very important, and this provision is not used at all. So, in order to invoke this, the person must be an addict. He must be charged either with an offense under 27 or offenses involving small quantity of narcotic drugs or psychotropic substances. The addict should volunteer to undergo medical treatment for de-addiction. And after undergoing this treatment, he shall be granted immunity from prosecution. But first, he must establish that he is an addict. So the reason for not using this provision is that we do not have any clear-cut rules as to how this provision is to be worked out. So there must be a provision under the rules that the investigating agency in such cases should identify the addicts at the very inception and grant them the benefit of this beneficial provision. The next we have is section 67, power to call for information. Now, any confessional statement recorded by the empowered officer under 67, whether it is hit by section 25 of the Evidence Act or not, the matter has been referred to the larger bench and the matter is still debatable. Then last is forfeiture of illegally acquired property. Now, this has been added by the Amendment Act of 89. The object is to forfeit the gains or the proceeds which one acquire from dealing with this contraband, and which is one of the main motivating factor for the accused to indulge in such activities. Now, the chapter applies to all those persons against who are arrested or against whom authorization has been issued or detention order has been made in respect of offences punishable with 10 years imprisonment or more. then the time period is that the property should have been acquired within the period of 6 years from the date of such arrest or authorization or detention. Then the competent authority must identify the illegally acquired property. After identification, there has to be inquiry and forfeiture by the competent authority. There is a provision of appeal before the tribunal. The civil court jurisdiction has been barred under the Act. Last is whether the Drugs and Cosmetic Act as well as the Ndps Act both are liable to be invoked simultaneously in cases where there is an infraction of the provisions of both the Act. Answer is yes. Ndps Act applies additionally to the Drugs and Cosmetic Act. So in those cases where the accused has violated the provision of the Ndps Act and rules, as well as under the Drugs and Cosmetic Act, he is liable to be prosecuted under both the acts. Then we have a case of Inderjeet Singh Lati case. It deals with the interim bail pending the Cfsl report and simultaneously application of both the acts. Saurav, I am done with the presentation. Now we can invite few questions on the topic if they have any.
Yes, thank you, sir. It was a wonderful, interesting and a very enlightening session, I would say. So there are a couple of questions which have come. But before that, there are a couple of requests which have come. So one is that Shri Deepak Sharma has requested that we should arrange one of the sessions on Prevention of Corruption Act. So I will pass on your request to the keynote speaker, Shri Taraji, for sparing a time on Prevention of Corruption Act also, sir. Then we have another small request which has come, sir, regarding the slides or the compilation of important points and the judgment. So we would try, and if at all you can leave your WhatsApp or a mail ID, we would try and send you the compilation. Then, sir, there is one of the question which is regarding why not the M29 FSL form or M29 form, that why they are not filled at the time of the recovery, but they are filled at the time when it is produced in the court. So what is the reason behind this? This is again by Mr. Deepak Sharma.
Yes, that's a very interesting and good question. Now we have already noticed the concept of link evidence in the context of Ndps Act. It intends to preserve the sanctity and integrity of the case property from the time of its recovery till its production before the court or its disposal otherwise. The Cfsl form is one of the important safeguards to maintain this integrity and sanctity of the case property. Now the obligation is that the investigating officer must fill the Cfsl form at the very spot when he has made the seizure of the contraband. If he is not doing so, and if he's filling this form subsequently, then this would definitely be one of the circumstances which the court would take into consideration to doubt the case of the prosecution. So mandate is they are required to fill at the spot. Now let us see Cfsl form. The moment the IO puts his seal on the case, the parcel of the case property, he is required to affix the facsimile of this seal on the Cfsl form by filling it. Then come the officer in charge of the police station. Now, when the IO will hand over the entire case property along with the accused to the officer in charge, he is again required to reseal the property with his own seal impression and again make the entry or facsimile of the seal in the Cfsl form. Then third is when the case property is produced before the Ilaka magistrate. Ilaka magistrate will verify from the Cfsl form regarding the seals on the case property, and then only he will order the reopening of the case property in front of him and directing the drawing of the sample and everything. Thereafter, he will seal the same with his own seal impression and then put the facsimile on the Cfsl form. So there are 3 stages at which this is required to be filled up, and if it is not being done, then this circumstance would go against the prosecution.
Thank you, sir. We have another question coming up from Advocate Rajinder Singh Pata. He asked that when police caught a person with narcotics drugs, will he be handed over? Will he hand the investigation to the other officer, or can he carry on with the investigation?
Who has
the question on the screen also to you, sir?
Who has affected the search?
When the police caught a person with narcotics drugs, will he hand the investigation to the other officer, or? And what is the position of law also on this, sir? So kindly throw some light.
I have already discussed this in the presentation itself, that so far as the this part is concerned, the matter has been referred to the larger bench, that whether one who has effected the recovery or who is sending the RUCA to the police station for registering the formal FIR, whether he is entitled to undertake the remaining part of the investigation, or is he required to appoint some another independent investigating officer to take the further investigation. But this part is still debatable. But as of now, the procedure which the investigating agency are following is that they are appointing an independent officer who is taking up the further part of the investigation after the recovery has been effected at the spot.
Thank you. So hopefully, Mr. Rajinder Singh, your query must be clear. We have another question, sir, from a young female advocate, Nisha Kamboj. She is asking that, is it mandatory to get the signature of public witness on the consent memo or search memo? So it's part of the procedural issue.
It is advisable that signature may be taken of the independent persons or witnesses whom the investigating officer has associated during the search and seizure proceedings. But even if there is no signature of the independent witnesses on those memos, but their presence is established and otherwise reflected in the case diary and other documents, and they come forth in the witness box and support the same, then it's the obtaining of non-signature on these memos would not materially affect the case of the prosecution, because it only affects when the independent witnesses, they deny being part of the such proceedings, or their signatures having been obtained on the blank papers, but they having not witnessed any such proceedings in their presence.
Thank you, sir. Hopefully, Nisha, your query must be clear. We have another, sir, question, which says that can an accused pray to the court for retesting of the sample of the contraband?
Yes, he can. I have already indicated the 4 grounds which have been involved by the judicial courts for retesting of the sample, but all those pertains to situations where at the end of the Cfsl, there is some difficulty in the sample or in the property.
Thank you, sir. And hopefully there are no other questions today. So the second session was, sir, much enlightening. We have another one coming, sir. If you permit, we can take this question, and this could be the last question for the day. We have Mr. Rahul Arora, who is asking, is it mandatory to prepare a report by a superior officer under section 55 or 57 of the Act, and about its relevancy?
55, 57, I have already stated, Saurabh, that their non-compliance as such is not fatal in the case of the prosecution, but that can definitely be taken into consideration for appreciating the evidence of the prosecution. Now 57 is regarding the report of arrest and seizure, which the investigating officer is required to prepare and dispatch it within the 48 hours to his immediate official superior. The object of this provision is to keep in loop the superior officers regarding the offences under the Act. So it serves twofold object. One, the superior officer will be in the knowledge that so-and-so investigating officer has undertaken the investigation in respect of the offence under the Act. He can give guidance, he can check, so he can deal with all these mechanisms once this report is there. But if there's a delay in dispatching the report, or no report was ever made to the official superior, so in that case, if it is coupled with other circumstances of the case, then it may create doubt in the case of the prosecution.
Thank you, sir. Sir, if you permit, there is another question from one of my dear colleagues and friends, Mr. Sukhwinder Singh Nara, and who has been very active and doing a lot for the fraternity. So he asked that, can the accused request for retesting of sample from the private lab?
No, that is not permissible.
Thank you, sir.
I've already stated that there is no provision under the Ndps Act for retesting, unlike we have under the Drugs and Cosmetic Act or Pesticide Act. It's the judicial courts, they have evolved a few grounds for retesting, and now the time limit has also been put by the Apex Court, that is 15-day time limit from the date of filing of the police report or challan. So only on those limited 4 grounds the retesting can be sought.
Thank you, sir. Sir, another short question before we finally close for the day, and it is from Mr. Bikramjit Singh Arora. He asked that videography of search and recovery is mandatory in the case of chance recovery.
Mr. Arora has put a very interesting question. I did not refer to this part in the PPT because of the time constraint. Now, this basically deals with section 41, 42, 43 of the Act. Now, there was one bill also, which was tabled by Mr. Chutala when he was the MP of
Mr. Sarah probably is not a little audible, but Mr. Arora, he was in the process of answering your question.
Yes,
looks like that there's some technical glitch on his side.
Shall I repeat it?
Yes, sir. Need to be repeated because there was some technical glitch which took place.
The question of Mr. Arora was regarding section 42 and 43 of the Act, the employing of body camera by the investigating officer while effecting search and seizure proceedings at the spot. So in this regard, I wanted to draw their attention to one bill also, which was tabled by Mr. Dushyant Chutala, an MP from Haryana, seeking amendment to section 42 of the Act, which stipulated that the investigating officer should employ body camera while effecting search and seizure proceedings at the spot. But that bill lapsed and 42 was not amended. So as of now, we don't have any such provision, but if they employ the body camera while effecting search and seizure proceedings, this will definitely lend credence and more authenticity to the same. But there is no requirement under the law.
Thank you, sir, for enlightening us and wonderfully clarifying the issues which were in the minds of the viewers. And I have no words, especially, sir, to thank you for such an enlightening and a wonderful session we had today. It was it's hour and a half hearing on the subject of NDPS Act, Procedure and Practice, was our fortune. And in this time of pandemic and lockdown and gloomy days, we have such a wonderful interaction and such a wonderful informative session, I would say, which has uh, being food for our mind, and which has clarified so many things, especially for me and for many other viewers who joined, and some of them who couldn't join initially. I have their queries and issues with me. We will be sending them the recorded version. But once again, on my personal behalf, and on behalf of the Forum Global Citizens One Word Affair, um, we are really, really thankful to you, sir, for granting us and sparing this time for creating awareness and helping in our mission of creating legal awareness for the legal fraternity. Thanks a lot, sir, and hope to see you again on a wonderful evening. And to all the viewers who have joined in, I am really, really thankful. There were little technical glitches initially, which were kind of commercial breaks, I would say. But in this kind of technological connectivity, we remain connected, we remain informed, and we remain safe. I would request all of you to stay safe, stay blessed. God bless you. Good night, Shabba Khair, and have a
Thank you,
safe
Saurabh.
coming
Thank you
week.
so much.
Thank you. Thank you very much, sir. Thank you.